Hello. Welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gaff. I'm a senior member of the IEEE and partner at the McDermott, Will & Emery law firm in Boston. The IEEE is presenting this podcast in conjunction with my column that appears each month in Computer Magazine, a publication of the IEEE's Computer Society. That column discusses legal issues relevant to people in the computer hardware, software, networking, and service businesses. In the last podcast, I discussed some basics of contract law. This podcast will cover some questions that readers have raised, which is the topic of my April 2014 column in Computer Magazine. Readers sometimes send questions to the editor of Computer Magazine or to me about topics covered in my Computing and the Law column. These questions are encouraged, and I try to answer them from time to time. Please keep in mind, however, that my answers don't constitute legal advice, and no one should take any action or make any decisions based on those answers. If you have a matter that requires legal analysis, irrespective of how similar it might seem to be with what I discuss, retain a lawyer who can analyze the matter and provide legal advice that's specific for your situation. With that in mind, let's proceed. Now, the questions that I addressed in my April column relate to situations that might present themselves under the new U.S. patent laws. Before turning to the questions, let's review those new laws. Up until last March 16, 2013 to be exact, the U.S. operated under what was called a first-to-invent system. That meant that the laws relating to U.S. patents were designed to benefit the first person who came up with an invention. If multiple people independently came up with the same invention, the person who did so first was the one eligible for a U.S. patent. When, under this system, disputes arose about who was entitled to a patent, it was often necessary to look for the laboratory notebooks, development records, and other evidence that shows when the invention was first made. In many instances, those records weren't available or in the proper form to serve as definitive evidence at a later time. Consequently, resolving those disputes could be a costly and time-consuming undertaking, requiring considerable amount of litigation. On March 16, 2013, the U.S. changed its patent laws to become what's called a Firsttofile system. Under this new system, the first person who files a patent application is the one who is eligible for a U.S. patent. This is similar to the systems that are in place in many other countries. In contrast to the first-to-invent system, if multiple people independently come up with an invention, the person who was first to get his application on file with the U.S. Patent Office is generally the one who's eligible for a U.S. patent. I say generally because there are certain exceptions to that relate to specific situations. Also, the March 16, 2013 date isn't absolute. It's possible that a patent application filed after that date will be subject to the old U.S. patent laws. For example, if the application claimed priority from another application filed before that date, the new application will be subject to the old law. However, if the new application has claims in it that relate to anything that wasn't disclosed in the old application, then it will likely be subject to the new law. Let's go back to the exceptions that I referred to earlier. U.S. patent laws traditionally give inventors a so-called grace period that allows an inventor to go public with his invention for a limited time before filing a patent application. If the inventor wants to pursue a U.S. patent on his invention, he must file an application within 1 year of going public. Offering the invention for sale is one way to go public. A grace period is unique to the U.S. Most other countries don't have grace periods. In fact, many countries have a strict absolute novelty requirement. That means that if an invention is disclosed before a patent application is filed, the invention won't be eligible for a patent in those countries. So, putting an invention on sale before filing a patent application will likely end any possibility of getting a patent in many countries outside of the U.S. One exception to the first-to-file rule relates to publishing details about the invention. Assume, for example, inventor A and inventor B are working independently to come up with the same invention, with inventor A being the first to do so. If inventor B files his patent application before inventor A files his, then inventor B will be eligible for a patent and inventor A won't. This is the result even though inventor A was the first to invent. But if inventor A disclosed his invention before inventor B filed, for example by publishing a paper about his invention before B disclosed anything, then A could file an application based on the date of his earlier disclosure. That would make A eligible for a patent and would prevent B from getting a patent. However, it's important to realize that what's in A's patent application must mirror what's in his disclosure if he's to get the benefit of an earlier date. If his patent application goes beyond what he disclosed earlier, then A won't get the earlier date and will lose to B. The questions addressed in my April column focus on test marketing, trade secrets, and defensive publications. I won't repeat all of the specifics here. However, a common theme is whether and to what extent an early disclosure will prevent someone from getting a patent. As I said earlier, a public disclosure by an inventor generally won't hamper his ability to get a U.S. patent on his invention as long as he files that application within 1 year of that disclosure. Outside of the U.S., however, the disclosure will likely end any opportunity to get a patent. Putting an invention on sale for test marketing purposes, for example to gauge interest in the invention, would likely be one such disclosure that would have these kinds of repercussions. Trade secrets are attractive because they're good for as long as they're kept secret. Compare that to a patent which has a limited life, usually of about 20 years. Trade secrets could, in theory, last forever as long as the secret is maintained. On the other hand, any disclosure, even if it's inadvertent, will destroy the trade secret. A trade secret that was disclosed probably won't be eligible for a patent, so it's unlikely that the original inventor could recover some protection by filing a patent application after an inadvertent disclosure. Those who are told the trade secret probably won't be eligible for a patent as well. Publishing a paper on an invention is a well-known way to create prior art that might prevent others from getting a patent on the disclosed subject matter. The paper is usually called a defensive publication. That method should still work under the Firsttofile system, but it's possible that another party's prior publication might make him eligible for a patent, thereby undercutting the effectiveness of the defensive publication. I hope that you found this podcast helpful. Please keep in mind that if you encounter situations like these, you should consult with a lawyer to get advice and decide on a course of action. The discussion above, no matter how similar it might appear to your situation, shouldn't be relied upon as legal advice. Consult with your own attorney before making any decisions on how to proceed. Stay tuned for next month's column in Computer Magazine. Until next time, this is Brian Gaff. Feel free to contact me via email at bgaff@mwe.com. Thank you.